Welcome to this meeting of the Milton Planning Board. I'm the senior member and therefore will preside because the chairman is out of town, but through the miracles of modern technology, he is with us by, what is the equipment called that he's with us
Just
by?
a video chat on Google via the laptop to my right.
How great is that? Okay, now, why don't the other members introduce themselves to the viewing public?
April Amaro, member.
Michael Kelly, member.
Tim Serwinski, assistant town planner.
And we are unclear whether or not
Chair
Cheryl,
of Abstentia, calling in from the Blute Conference Room South.
okay, do you want to repeat that, Brian?
Oh, okay. Brian Ferris, member.
Oh, nice. Okay, now, Cheryl Togias has a family emergency and may not be with us. But if she's not with us, she will view a tape of the meeting. So we really need sound on this tape. Okay. We're going to meet again on June 23rd, July 14th, July 28th. We used to take the month of July off, but we're not going to do that this year. Too much to do. The minutes of December 27th, I've made some changes and given them to Julia. And if anyone else has any changes, they can do the same thing. And we'll consider them at a future meeting. Now we're going to do citizen speak, where any citizen who wants to address a matter of concern or relevance to the planning board can address the board, but don't talk about Kinsale Lane or Thayer Nursery. Yes, sir.
Kevin Walker.
Come on up. Introduce yourself. You're being recorded and televised.
My name's Kevin Walker.
Have a seat.
I was just going to get my...
Tim, could you move me over so I can see the presenter, please?
Will do.
Thank you.
Can you see him?
I can, yep, thank you.
Good evening. My name's Kevin Walker from 1776 Canton Ave. I spoke a few weeks ago. I'm a direct abutter to the proposed development at the Carberry Estate Farm. If you don't mind, I'll just stand up. I'd like to discuss zoning, the master plan changes, and I may have some of my information correct, but I may not. and I
Could you grab that
Sure.
mic right there? Thank you.
We will be forwarding a detailed letter expressing our opposition to the proposal and any zoning changes. After the meeting last 2 weeks ago, I went back and watched the video, and a few things surprised me. The first thing was that the developer's attorney utilized ratios from the 70s, the 80s, 1998 to justify changing the zoning for this land. This is not consistent with the master plan, Housing and Neighborhoods, you know, the Master Plan Roundtable, and the Housing Production Plan of the town of Milton, which is all 2014. The big piece of this is that they want to decrease the open space by 29%, going from 70 to 50%, which is not according to the bylaw of attached cluster housing development. Now, I found something very interesting that was said about how the owner of the property set the market price. Well, based on the definition of market price, it's valued at what it is now. And if someone comes to the town, the government, and say, we need to change the zoning to make this deal work, it makes no sense. That's not why, excuse me. Why the town put together the master plan. It has the bylaws and follows the laws of Massachusetts. And the whole purpose of this is to conserve open space. Then I hear, oh, we're working with the neighbors, we'll continue to meet with them, but we don't think we're going to get at a count. Well, I haven't got any calls. And I haven't seen any number come down. I hear threats of 40B. And here, guidelines, rules, regulations. I've done a quick analysis of the property for 40B, the access, the road, the topography. You have to sell those units for less money, market. So they threaten 40B, or we get this. I mean, I was in total shock. I can't believe that they actually put this on tape and said, we can adjust. This is their own form here. We can change this amendment, we can do this, if you don't do this. Who else is this gonna benefit, this change? And then, I'm looking through the zoning, I can only find a 2002 map. I only find amendments as recent as 2007. I go through the town's land and say, who else is gonna benefit from this? The zoning change. Well, I can't find anybody. Maybe there's somebody in AA that now we're going to reduce the open space. And the whole idea of the master plan and everything is to conserve open space. Here's the topography. Here's the open space. They want to go change it to an E district or amend the Woodmere St. Pius bylaw. I can't find that on the internet. I don't know, maybe, I don't know. Special permit or threat of 40B. It's against everything that the planning board is responsible for. If a developer comes in to the planning board, we gotta start at the beginning. What was the intent? What are we looking to accomplish with these areas? All this money went into these things. And then you have a developer who says, the owners set the market. We need to change so we can meet that. That's not how it works. That's not government. It's all right here. So I will put together a letter detailing all of this. And like I said last time, to work to back into the number that the developer has to pay the Carberries is beyond my comprehension. That's not how government works. Thank you. Have a good night.
Thank you. Anyone else for citizens speak? Okay. Now, we're going to briefly discuss the non-conforming dimensions bylaw that you received in your packet. And this was what we had before before people began changing it. And eventually, we got something that was incomprehensible, and we had to back off. Does everyone have their copy? If they don't,
I came directly from the airport, so I have nothing.
okay, here.
Thank you.
You're sitting next to Brian, by the
Hi,
way.
Brian.
Hey, Cheryl.
Oh, she's got one.
Well, take a look at this, and we will discuss it further. But Tim, you might ask Ned, Bob Sheffield, and Marion McKettrick as to what they'd want to do here. But that sort of gets us into Senate 2311, which is the so-called Zoning Reform Act, and that would change things. So let's consider this in conjunction with 2311 and consider that maybe we should wait and wait until the dust clears.
I mean, specifically, well, I don't specifically, generally, what 2311 would do is, and what I've read, I haven't read the whole bill like Alex has, but basically, the issue behind this non-conforming uses amendment was, the standard for a variance for a dimensional change is so great and so burdensome that people are expending a lot of time and effort and money for something that should really be a lot simpler. And one of the elements in the zoning reform bill is to sort of lower that burden for dimensional variances. So depending on how it all pans out in the Senate and the House, the work that the planning board has been trying to do might be done, for it. So kind of a little bit of a wait and see.
What they want to say by changing the variance language is to say where little enforcement of the zoning ordinance or bylaw would result in practical difficulty, financial or otherwise. So practical difficulty, financial or otherwise, would be the new standard. And as you can imagine, that would cover more or less anything. We're at, yes.
So the bill was on the floor of the Senate today. Did it
Yes.
pass?
I was kind of hoping I would get an email about that today, but I didn't.
And then so this would have to be voted on by July 30th?
It would go to the House, and the House would probably change it, and there'd be a conference committee. And there would be, it would then, if it got passed, go to the governor, and the governor might have a little bit to say about it.
I guess my question is, does it require a roll call vote? Because if it does, it has to be taken up by July 30th. And it seems like a lot of things still need, a lot of boxes, as you just
They
described, need to
said
be
they were
checked.
going to debate it today, and someone said they were going to vote on it today also.
Senate.
But the Senate,
Right.
right. But in any event, I think that Tim, you can send out what you sent me, and people can print it, and we can discuss this further.
Yep.
Because certainly, if the Senate passes this, we may have some comments for the House. And the House does not march in lockstep with the Senate, not always. So, gets us to 7:15. And Kinsale Lane, Mr. Corcoran.
Bill and Mike, I'd ask if you can keep an eye on Brian, and if we lose him, give me the high sign. Get him back.
Or if he falls asleep.
I don't think that would happen.
If his eyes start to close. Proceed.
Good evening. Apologize for being a couple minutes late. Ned Corcoran here on behalf of Dennis Cohane.
Let me just say, this is a continued public hearing, which we continued at a prior meeting to tonight at 7:15, and we've reopened the hearing, and we're going to hear from Mr. Corcoran.
So, thank you. We were last on a site walk at early May, and at the site walk, I think the board got a good look at the terrain of the property, how the two lots lay out, and there was discussion about the notion of allowing the gravel to remain as is on the portion of Kinsale Lane that has been built out with gravel to the Cohane lot line, and then grass pavers, grass paver roadway being installed on the Cohane portion of the property with the adequate frontage, 150 feet, so that that second lot has legal frontage on a roadway. Its access is off of the private way that comes in from Brush Hill Road, and so from a practical perspective, Kinsale Lane serves as emergency access only for the Cohane lot. His access is actually in off of the private way. Dennis Cohane and the Ambroses, the next door neighbors, have agreed that that would be an outcome that they would like to see happen. And so the next thing for us to do would be to prepare a new final Mylar plan for presentation to the board and return back in July for signature. But before we make that, spend the money to create a new Mylar plan, I want to make sure that the planning board is willing to vote that outcome so that we don't spend money on a plan that's not going to be acceptable later. So I'd like to have that discussion with the board, understand the board's pleasure, and to see whether or not we can get to, the board is willing to vote yes, that based on that notion.
Well, is the notion to use the paving blocks on the street as originally configured, or are you going to reconfigure the street?
I think that there's a need to have 150 feet of frontage on that roadway. As originally shown on the plan, the roadway comes in off of the end of Kinsale Lane at the Cohane property and takes a left. If you recall, there was a large tree.
Right. It goes
near
right through the middle of the tree.
So I think the second point of that would be that the roadway would flare right and left so that the frontage
Get it
would
150.
be 150 feet without having to affect the tree. And that's
Which I thought was a good idea. So you're going to get my vote.
Thank you.
Does everyone else remember the site?
Yeah, although I thought the pavers were going to make it over to the existing bituminous concrete pavement in the driveway there, but now it sounds like it's not.
Now it's going to be more or less a little
T.
A little T.
I think that's really a perspective from the board's perspective. We need to do 150 feet. Where that nets out, I think the Cohanes are fine. It could swing to the side of the tree and connect up to the driveway. I thought that the discussion at the site walk was more towards a T approach. I think we paced off about 60 or 70 feet to the right off of the end of the driveway.
Well, the fire truck can turn around with the T, and that's the principal concern, because, as you recall, there's a hydrant right at the end of the gravel portion. So configuring the road it seems to me, I personally think the T would be better than trying to snake something around the tree.
Well, my only thought was, that if it's most significant purposes for emergency, that you'd be able to make the complete loop. The fire engine will turn around on T, but the fire engine would turn around on top of his house if it needed to, but the road becomes more or less irrelevant. I mean, the fire engine would pull in there and turn around the grass if they had to.
Unless it was muddy.
Even at that, it'd be hard to stop the fire engine.
Now, Bill, you've got the answer, right?
Yes, I do.
Oh, good.
I actually visited the site with the fire chief to address these particular issues. His comment was, he may have a pumper pull down Kinsale, turn on to the pavers. He has no intention of having the ladder pull anywhere. It'll pull into Kinsale, period. It'll fight from where the turn in the road is. It is not going anywhere closer to that house. And it's a good place for it to set up because of the hydrant there. The fire chief was concerned where Dennis's house is now, the distance from the previous fire hydrant, which is not right outside of Kinsale, it's actually out and down the street. So he was concerned about the length. He likes it where the new hydrant is right now. He's not taking and sending a pumper down the other driveway off of Brush Hill. He may send it down that lane, but he has no intention of sending it between the pillars on the lane at Brush Hill, off of Brush Hill. Everything's gonna be fought from Kinsale or from the lane off of Brush Hill, not Dennis's driveway. They won't go into his driveway. You may send an ambulance or a police car through and up, but you're not putting a fire truck in there.
Right. Well, so that would indicate that linking the road to the driveway is probably not necessary.
Correct.
What do you think, Mike? Can we,
I think we're bending to the point where the road isn't necessary, but whatever.
Does it make 150 feet is the big question.
getting 150 feet is what's necessary with pavers, and
Yep.
it's not going to be cheap. So, as I say, I think
Another
that,
comment, I want to raise that from a precedent-setting standpoint, we have, Curry College did a similar process to this for emergency vehicles. They put in the pavers. And I think we were comfortable with that. It's not intended to be regularly traversed by vehicles. It was designed for emergency purposes only. They are required to maintain it, and I believe they're required to plow it, but Bill will have to weigh in on that.
They do.
So they're required to plow it. So from a precedent standpoint, going forward, I would ask the board whether we need to put in a condition that this be regularly plowed or maintained. The second piece that I would like to discuss is whether we should require this to be a condition that this road become the originally required asphalt service if it ever becomes the main point of access for the Cohane property. Because certainly if it becomes the main point of access, if for some reason the driveway off the lane was abandoned, we would not want to have a precedent for a dirt road getting down to this lot.
well, it wouldn't be a dirt road, it would be a paver road.
Gravel road, right.
But Tony has some views on this, Brian, and why don't you come up and introduce yourself and tell
I
us
would
what...
just, while Tony's sitting down, I would just make the point that Dennis is one of 5 properties that have deeded access to that private way. It is essentially not foreseeable that the access would be lost
Unless he gave it away.
unless he gave it away.
Right.
He's certainly not.
And that would not be a smart thing to do.
If substantially affect his own value if he were to do that. So.
Hi, my name's Tony Ambrose. Thanks for having me back. I spoke to you at the previous meeting. I guess the reason for me being here was obviously to express our position and just to reiterate everything that Ned has said. Me and Dennis are neighbors. We are in agreement. You know, we want to put this, my wife and I want to put this behind us, obviously. And so we're okay with the gravel, and obviously Dennis can figure out what he's going to do with his pavers and on his side. I guess my biggest concern now, Brian, you just mentioned it, basically, and Ned just kind of reiterated, you know, because of the fact that Dennis has deeded rights to Brush Hill via this private way, and so do 5 other families, the fact that he has legal deeded access, to put language, you know, stating that if for some reason the entire lane becomes bituminous concrete, if for some reason we ever put our house on the market, I don't think a buyer would want to see that, and I think it really, in the end, it really hurts us, especially because there's 5 other homes accessing Brush Hill via that lane. Dennis would never in a million years give away, deed away those rights. I just feel like in the end, who gets hurt if this language is inserted? It really is my family and our rights as homeowners to put our property on the market if we want, and not to have to overcome this kind of a statement. As I think it would be something we probably could overcome, but would a buyer, I think this would be a huge red flag. So Brian, I was just hoping to appeal to the board's better side and just say, from our perspective, I understand precedent. This is a 2-family home subdivision. This isn't a 7-8. I'm not sure how big they get in Milton, but I'm assuming they get larger than 2. It's a unique situation where we are. So just all those facts being stated, that's our position. We are perfectly fine with everything else. We want to put it behind us, but I just feel like the asphalt stipulation, Brian, that you just verbalized would be detrimental to my family and the status of our home if we were put on the market. So I just wanted to state our position.
So, can I respond to that, Alex?
Yeah.
Okay, so I appreciate everything that Mr. Ambrose just said, and I commiserate with it as well. And I, frankly, I'm not sure I disagree with his concern, but a couple of things that, first of all, he points out that it's very unlikely. So I think we're acknowledging that it's very unlikely that this would happen. But we really, from a planning board standpoint, we need to defend the community. And the very fact that this is a 2-family home subdivision is actually what worries me, is if we start making all kinds of waivers on roadway surfaces and access points and emergency vehicles, we're going to start to see some of these lots get cut up in town where there isn't appropriate frontage, but it can be made, but they don't have to pave it, so it's not detrimental. I think we're opening a can of worms here, and I think we have to be very careful on this issue with this surface. I think it's very unlikely for both Mr. Corcoran and Mr. Ambrose that this will ever be an issue. But as far as I know, the house was purchased on the basis that this was going to be a paved road, and I have a really hard time overlooking this precedence problem on a town-wide basis due to in the very unlikely case that this ever did happen. I think it's partially driven by precedence, and it's partially driven by what we originally approved. I think in my mind those have to take precedence and have to take priority.
So can I respond briefly to that?
Sure.
Brian, I think from your perspective, saying that we bought the home with the understanding that it was going to be paved, we purchased the home with the understanding that we were going to have and I'm probably not, this is not the right verbiage, but having the subdivision plans approved to approve gravel and whatever Dennis was going to do on Dennis's side of his house. So I understand what you're saying about that. I just feel like I go back to the point saying, if it's so unlikely for this ever to happen in this occasion, because it is truly only hurting us, is there a way to see past this, knowing that we've brought these issues to the forefront? The board is obviously much more keenly aware of these situations moving forward, I would assume. Is there a way to make an exception for us, and really appealing on a personal level to say, my wife and I both have jobs where we could be relocated within the next couple of years. I just foresee this being a huge issue. Not that it's not we can't overcome it, but I just feel like, is there a way to see through this issue with all those pieces being stated? If the answer is still no, then I mean, we're very understanding people. I just wanted to make sure I restated how kind of important and personal this has become for us. I feel like we've really given on not, we wanted pavers for our side. We understand that's not going to happen. That was a huge expense for Dennis. We're okay with the gravel. We've put a lot of money into the house. We've built that outside up considerably from where it was. We've added a lot of value, I think, to that home. So that's my spiel, Brian. I just wanted to kind of restate and potentially appeal to the other side and get this to where we can put this behind us and take the asphalt conversation off the table.
It seems to me that we are requiring a roadway which is going to have an adequate surface for its potential use. There are a number of houses in Milton that have driveways accessing them, which do not access them through their frontage. There are many, many houses that do that, and I don't see that if we require a adequate surface for the roadway, which is not going to be any cheaper than the pavers are not going to be cheaper than asphalt, in my humble view, that I don't think people are going to rush in to do it. And we do have a drainage issue here, which is, I think, pertinent. There's a good reason to use pavers to try and keep the water in the ground rather than in the cellar of the house. So I don't see that there is a precedent problem, but certainly we can include language in the subdivision approval saying this is no precedent, and give a number of reasons. All right, anyone
That
else?
is something that I could be comfortable with, as long as the reasons presented as sort of a level of hardship, and I think that's a good compromise and a good solution.
I agree with that, because the biggest fear I have is what Brian virtually just pointed out, and that is that somebody else is going to say, you say it's a sufficient surface, it's gravel, well, I got this new product, it's chewed up tires, I think it's sufficient. Or I got this other product, why do I have to build a road? He didn't build a road, and it goes on and on. So, yeah, if we set some pretty significant, hardship parameters, then maybe we can dissuade the next guy from coming along and saying, well,
I think that we can write a subdivision approval which would dissuade the next person.
I mean, I can understand the drainage, but drainage can be handled in many ways.
Drainage can be. It seems to me like a good plan for this particular situation.
I think we need to find a way to make it just work in this situation.
Right.
So that somebody doesn't come along and say, well, it would work fine for me too.
Well,
Look, I agree with what you just said. I'm looking forward. I'm foreseeing a situation where, someone comes in and buys all 5 of those homes. We now have a developable parcel. They don't want that property accessing it that way anymore. It's out of the box, and it's very, very unlikely, but it's something that I just want to be careful about, and I do believe that there is a precedence problem. So I disagree a little bit with Alex on that point, but I think as long as we can establish something that is legitimately a hardship, I'm fine with going that path.
well, the other thing, of course, is that precedents with the planning board are non-binding. In other words, there can be a precedent and we can ignore it.
We just have to be generally fair.
That's
I
just
think,
what
I
about
think
ours.
I do think you have the authority to make specific decisions based on specific fact patterns. And I think in this case, there's a sufficient fact pattern with the hardship associated with it, that the board could make that. I'd be happy to work with the board on specific language that could be reviewed.
I know that there's specific language we can do. Come up with a good plan with 150 feet, and I get the sense of the board that it's going to fly.
Environmentally, it's a much better outcome, in my opinion. So I would be in favor.
I love the plan. I want to be very clear about that. I think the plan is a great resolution, and I think it's the right application for the site. I think I'm just trying to deal with administrative problems, so as long as we have a solution to do that, I think it's the right plan.
Okay.
All right.
Thank you.
Thank you very much.
Thanks.
Appreciate it.
Okay, now, the highlight of the evening, the Fair Nursery application. Now, people might say, I thought you did the Fair Nursery
I would say that.
months ago. And
Extensively.
in fact, we did do the Fair Nursery months ago. And there was an appeal from our permit. And it turned out that there was, that the 1967 special permit was granted under a subsection that we didn't cite in our zoning. And the net result was that land court said, okay, we see that you're going to go fix the zoning, and then start again. Yes.
Excuse me, I don't think the Cohane, the Kinsale Lane subdivision hearing was not closed.
Oh, well, we're going to continue it.
Continue to another time.
When do you want us to continue to?
July 14th?
July 14th at 7:15?
Perfect.
All right, so continued.
Thank you.
Can you just hold on one second, Ned? Just want to make sure.
You're checking?
Just want to make sure we're not booked. Clear as day, 7:15.
Okay, so the land court spoke, and their nursery has filed a new application, and some people might think that they would have just taken the old permit and stapled it to an application and say, please give us this permit again. But nothing is ever easy, and their nursery has changed their application. So my suggestion is this, that we hear from their nursery and we get specification of exactly what changes they want to make in the permit that we issue. Then we'll hear from staff to see if they have any observations, good observations. And if the board has any general questions, it isn't, this is just general questions that can't wait. They can ask them, but I suggest that then we go directly to some of the opponents of this application, because they have a lawyer here in the room, and he has prepared a memorandum, and I think that if we hear from him, that would be good. And by then, it may well be time to adjourn for the evening, but we'll see.
Alex, is this a public hearing on this?
This is a public hearing,
Okay.
a duly noticed public hearing,
I have a quick question
Thank you.
of course.
before we start. What is the form of application? Is this a modification to the existing special permit, or is this a whole new application?
It's a whole new application, right?
And did we go through the normal process, Bill? Did we get fee, and did we collect the fee? Did we do technical review and the like?
We did do a technical review. I didn't do anything about the fee. It's the same thing that we've seen. This will be the third time. So I figured they paid it the first time, and I didn't It's up to this board to
Yeah.
run it again.
Yeah, I mean, I think if they're making changes to a special permit we already issued, I understand we have to correct the flaw, but I think, I'd like the board to consider whether or not this should be treated as a new application from a fee standpoint, because there are substantial changes that are gonna have to be now looked at.
I think we, in writing the new zoning article,
Right.
misstated. It-
Right.
and it
The
wasn't
the
applicant's.
article misstated a pertinent requirement, and no one noticed it until it was too late. But it does seem the planning board could be attributed some slackness. Some slackness. And I think that it would be unfair to charge their nursery a new fee. That's what I think.
That's where I was headed. Yeah. They
I
may
guess I disagree only because we're not fixing just that problem, that the applicant's taking this opportunity to change the permit.
But again, if the mistake wasn't made, maybe I'm jumping to a conclusion, but I don't know that they'd be back here.
They'd have a permit,
They'd have
They'd have a permit.
which would be
That would be
under
great.
appeal.
I mean, maybe they're using this opportunity, but we initiated the opportunity, so I don't think it'd be fair
Alright,
to.
well, just wanted to raise it.
I tend to agree with Alex and Mike.
All right, so let's, shall we, before we do anything else, waive the fee? All
So
right.
moved.
Do we have, okay.
Second.
Do you want to apply the previous fee to this? You're not
Right.
waiving it, right?
Right. Well, I'm waiving a new fee and applying the old fee to this.
If we have the right to do such.
Okay,
So that is my motion.
Second.
and we have a second. Do we have a discussion? We have no discussion. All in favor? Aye. All opposed?
Aye.
Okay, it's 4-1 in favor of waiving the fee. And the fee is waived, so congratulations. Now,
The other fees that they did have to pay, they have to pay for the advertising, they have to pay for the notification.
right, those are,
Paid for.
right. This is just the application fee,
Yes.
or application fees. Application fee, just, it's been waived. Now, Thayer Nursery, we want you to describe your application and tell us the differences between what we approved and what you now want, and give us the reasons. Now, during this presentation, if members on a particular subject have a question, feel free to ask it, because there's probably going to be a lot of stuff, and it probably makes sense to do it as we go along. Introduce yourself for the record. Do you want to look at, you've got the site plan, I think, Brian.
Yeah, I'm all set.
Okay.
Nice to see Maggie, though.
You can turn it so we can see Maggie.
So we are before you to submit our special permit application under the new zoning that was recently passed at February town meeting, so as to allow the reintroduction of our 50-year-old landscaping business back to its original site on Hillside Street at Thayer Nursery. My name is Maggie Oldfield, and I live across from the nursery at 237 Hillside Street with my husband, Phil Lang, and our 2 children, My daughter Chandler is a 9th grader at Milton High, and my son George is a 7th grader at Pierce. I am here with my brother Josh, who lives next to the nursery at 24 Forest Street, with his wife Stephanie and their soon-to-be kindergartner Frankie. My mother and my sister Hannah and her family also live in homes adjacent to the nursery. My youngest sister Bobby rebelled and moved to Canton Ave with her family. In 1963, my parents decided to make a home and a business out of a farm in my father's hometown. They imagined a place in which they could raise both a family and run a business, and it wasn't long before they had 5 children and 5 acres to grow. From this beginning, in the backyard of a discerning and sometimes demanding farmer and father, grew a business based on the principle that good plants and good service will always be in demand. The call of our father, Bob Oldfield, was too great to resist, so Josh and I returned home to work alongside him. Working at Thay Nursery has afforded us the rare opportunity to relish our childhood roots in a very welcoming and encouraging community, one that gave so much to our family while growing up. I truly believe that we have carefully cultivated a tradition that our father carried over from the Thayer family. You may not know that the Thayer Nursery farm site, located in historic Scotts Woods, has been in continuous farming operation since the late 1700s. The nursery, which is recorded with the Massachusetts Historical Commission as being historically significant for many reasons, has been a long and careful participant in the preservation of our nationally recognized district. Thayer Nursery is one of only a few properties still intact in town that maintains this agricultural legacy. Following the usage patterns of the rest of our country, Milton has lost most of our traditional farmland to development. With the value of land being what it has been challenging to prevent the indiscriminate sale of our land, but we are trying our best to preserve and improve the economic viability of a small business in our hometown. We believe that family-owned businesses are the foundation of our economy, not only here in Milton, but throughout the country. I think the appeal of residing in Milton is the underlying and uniting thread that connects us as a community. This sense of community is due to the long history of families and other small business owners that actively take part in our everyday life. Milton is one of the few remaining places where Main Street is still thriving, and we have not sold out to the chains or to the big box stores. We have had much neighborhood and community outreach that has included neighborhood meetings, selectmen meetings, warrant committee meetings, 2 town meetings, and as you know, an unprecedented number of planning board meetings. We have engaged experts to help us reconfigure our on-site activities to address abutter concerns, and we have received valuable and thoughtful input on our redesign. With many compromises on all sides, we believe we have laid out the best plan and put in place the best policies. This application is based on 2 previous applications that have been before you. So we are hoping, for all of our sakes, that the 3rd time is the charm. Our application meets all the requirements set out in the enabling zoning bylaw. No other business in town has been required to provide an employee list, an equipment list, a vendor list, a product list with quantities sold, a delivery schedule, or has even been asked to provide a tax return. We have been asked to go above and beyond what has been required in other special permit applications. You, the planning board, have set extremely high hurdles for us to clear, but we feel that we have not only met this incredible challenge, but we have surpassed it. Our drainage plan of this application meets Massachusetts stormwater management standards. These standards were established to encourage water recharge and to promote low-impact development techniques. Most new and existing developments typically add impervious surfaces, but we are not. We are removing over 10,000 square feet of impervious surface. We do not have any wetlands on site, and we are not increasing peak discharge rates and volumes. We are improving current conditions. Our special permit application is also consistent with several of the recommendations of the Milton Master Plan that this board sponsored, specifically the recommendations of 1, addressing non-conforming uses by declaring them pre-zoning or grandfathered properties and allowing them by right to expand to prescribed limits. 2, preserving Milton's historic characters by facilitating the preservation of historic buildings and landscapes and preserving and enhancing the individual character of each of Milton's neighborhoods. 3, to promote health and wellness through recreation and fitness, community gathering, and social capital. And 4, to promote economic development with townwide opportunities by creating vibrant mixed-use centers. This application, in our opinion, is essentially the same as the others, so we would like all previous testimony submitted by us, by our abutters, by our neighborhood, by the citizens of Milton, and by you, the planning board, to be included as part of this record in this public hearing.
All right, let me just address that. We're not going to do that if you come in with something specific, but we're not going to have to go through all those tapes. We're just not going to do that.
I don't want to do that either. That being said, there are a few small modifications that I would like to explain. 1, the first is in section 2, titled Definition of a Landscape Business Permissible Activities. There are no real changes in this section, except we added a page that defines landscape business activities. Through this multi-year process, we heard that a landscaping business was never defined completely, so we thought one should be included. Thayer Nursery Landscaping is one of 15 landscaping businesses that call Milton home, and we are all located in residential districts. Landscaping is a profession that involves the art and technology of landscape and garden project planning, construction, and landscape management for garden aesthetics, human enjoyment, safety, and ecosystem sustainability. Landscapers provide a service just as a carpenter does. Landscapers are outdoor craftsmen who have honed their knowledge and skill through education and experience. A skilled landscaper requires expertise in horticulture and artistic design. Just as carpenters do not have the luxury of a lumber yard in their backyard, landscapers traditionally don't have a nursery in theirs. Also, like a painter, you can tell which outdoor craftsman personally touched the canvas of each landscape. We all leave our own individual mark on each project we are so fortunate to work on. Secondly, in section 3.
There is a definition of landscaping business in the zoning, and that's the definition we're going to use.
Secondly, in section 3, titled Landscape Business may exist on a lot with other uses, including agriculture, greenhouse, nursery, and/or residential. There are no real changes in this section either, except we added definitions of the other uses that may exist on site alongside the landscape business. Again, through this whole process, we heard that there was confusion as to what agriculture and what nursery is, so we thought it would be helpful to include a comprehensive overview. Even though it has been made clear by you and by us that we are not applying for a nursery permit, we wanted to include a description of accepted products that are typically sold at nurseries today, not only in the town of Milton at Eagle Farm, A. Thomas, and Coulter, or those landscaping businesses that are housed at Copeland, but in our industry across the state and the country. Simply put, we are a horticulture farm that provides nursery and landscaping services. From creating an outdoor space to maintaining and decorating it, the concept of our nursery business is to provide a complete experience in outdoor living. We are a destination nursery that taps into and promotes as many local growers and vendors as possible, from farmers to artisans. We have learned throughout our history that our community in Milton wants to stay and shop in town. Thayer Nursery has been recognized by industry professionals outside of Milton. In 2015, the Mass Nursery and Landscape Association included us on their nursery tour and complimented us for being highly successful, for being on trend and at the top of our market. And as recently as in March 2016, Boston Magazine rated Thayer Nursery number 2 in the top 5 New England nurseries for sourcing plant material. Also in this section, for clarification purposes, we have included the language from the Milton zoning bylaws that allows agricultural uses as a matter of right, which is in section 3A, 4A, as well as language that allows nurseries to sell clean earth materials in the course of its business, which is section 4A, 5B. and language that allows nurseries to sell Christmas items, which is section 3A, 7D.
But you understand, and I do interrupt because your nursery business is not before us, and we are not going to say what we regard as proper for a nursery business. We're just not going to do that because it's not before us. We're dealing with a landscaping business. If you are operating a nursery business properly on your site, that's fine. And you do have an idea what your nursery business is, and it's either right or perhaps too expansive. But that's not for us to decide, and we're certainly not going to, in a special permit, get into what you can do as a nursery.
Right. I understand that. We wanted just
This
to
is
put.
background.
Correct.
All right. There's a fair amount of background in
Yes.
this.
Thirdly, in section 4, titled Plans, Rules, and Specifications of a Landscape Business, there are 2 modifications in this section. Under section E, titled Landscape Plan, under number 3, titled Fence Installation. The first is the fence setback along the back right property line is now 9 feet. When we were installing the post for the fence, we realized we would have to remove some of the existing natural vegetation to meet the 15-foot setback requirement. Removing 50-foot tall shade trees would have greatly diminished the buffer and would have been counterintuitive to what we were all trying to achieve. When we realized the situation, Josh called the abutter and the town planner to work out a solution. The abutter did not want us to remove the trees, so we approved the reduction of the setback, and the town planner authorized us to proceed with the fence installation. As you know, the zoning does not require a fence, and even though no other business has ever been required to install a sound barrier fence, we are willing to install one. The second modification concerns our southerly property line that was owned by Pam Lepore. Late last fall, the 3.5-acre property was sold. Upon a conversation we had with our new abutting neighbor, we were led to believe that the sound mat on the fence was not a necessary element in our redesign, so it was removed from our proposal. As we understood it, the plan was to clear out about an acre of natural buffer and to relocate the existing barn across the property to create a horse pasture along our property line. We were so excited to hear that he was bringing the neighborhood back to its original roots. In our childhood, all the neighborhood kids would ride both their horses and their dirt bikes in this field, so it was great news to hear he was recreating the look of what once was. It has been heartbreaking to witness the disappearance of stables and horses up and down the street, so we are so grateful for what he is doing. Other than those few changes, this application is essentially the same as the permit you approved and that you issued to us on December 18th. As you know, when the permit was appealed, Land Court did not uphold it due to a reference error in the enabling zoning that was drafted by the board and not caught by our attorney, town council, town meeting, or the attorney general. However, the judge recognized the intent was to allow all landscaping companies in Milton, including us, to apply for a special permit under this new corrected language. Like all neighborhoods, ours is a special one to us, and we want to preserve the character of it. We think it is important to continually strive to move forward every year, and making a positive difference for all of us is important to our family. Change can be difficult, but we are not proposing any significant changes to the permit that you would issue to us. Our business makes sense for our neighborhood. This special permit will allow us to continue what we have been doing, and all we are asking is for the ability to compete in the marketplace. I know this has been an especially long process for all of us, and we are looking for closure on this chapter of our Thayer Nursery history. We are excited about our redesign, and we look forward to working and growing with all of you. Thank you for your time.
All right, now you specified the changes. No other changes, so we can use our permit and just consider those few changes that you have described now, right?
Yes.
Yes.
Maggie, can you show us on the site plan, the fence that you described, the location being different, the extent of that
That property line is, would be located.
This area here.
Okay.
This corner here.
Okay.
If you look in that corner, you'll see the fence where it's, I think it's 14 feet comes across and all of a sudden it jogs up to 9. If they brought the fence to the, I think it's a 15-foot piece, wherever that line was, there's about 6 trees that would have to come out. 2 or 3 of the trees are about that big. I talked to Chris Stevens and said, you know, the whole idea here is save the trees, not cut the trees down. If you move the fence to the 9-foot mark, put the material on it, it's going up 8 feet. And if we just trim the trees up to the 8-foot mark, put in the fence, and then let the tree take up to the top, it's over 30-something feet tall. So it is a better sound barrier. Chris agreed, and Chris actually came to this board when we gave the last permit and stated that he was all right with it.
Excuse me, can you tell me who that is? Chris?
Chris Stevens.
Is that in a butter or?
He's the abutter.
He's the abutter next to, yes.
You can point out his lawn.
Yeah, that's right.
He was called when we were doing the actual install, and he came back to the.
This
the
is Mr.
site.
Stevens' property on Parkwood. See, his property line is this one right here. You can see there's a jog in the fence right there. This is right close to the Stevens line.
We think Stevens, you've talked to him?
I believe there's a letter in the
Okay.
last application that stated that he was good with it.
Okay with that. We probably want a letter from your new abutter about those changes too.
Yeah, if we don't get a letter from him, then we'll revert back to the original proposal and
Right.
do
Right.
vinyl as you wished. So
Okay,
I've reached out to him, I have not had correspondence, so if, my assumption would be that he would want the vinyl sound attenuation if I don't hear from him.
Who's the new abutter? Where's the new abutter?
I actually represent, his name is Jamie Cashman. So
Correct.
I'm sorry to interrupt the board. I actually represent Mr. Cashman, and I'm happy to address these when it's my time.
Well, we're going to hear from you, Mr. Dunn, shortly.
So our goal is to address whatever his needs are. If
Okay.
he wants the membrane, he gets the membrane.
Okay.
I was just confused. At one point, you said a fence wasn't required?
No, in the enabling zoning.
No, the enabling
Special
zoning
permit.
allows there to be a fence if it's needed.
And we decided it was needed.
And we decided it was needed.
All right, I
In
And
the
we
special
decided
permit,
that
though.
sound attenuation was
Then the other
needed
point
too.
is, on the changes, it would be nice if we could have it highlighted.
Yeah.
I'm not following exactly what the
I-
change,
I-
unless I guess I could
We-
go the old
I
one.
think I think, what I see is this. I think that we have their application, we have the permit, they've described the changes. We can use the language in the permit and we can consider those changes that they've suggested. We know what the changes are. We will work from our permit as a base. And
And insert the changes into the permit.
and insert them in if we decide that we think the changes are worthy. And so basically,
So this doesn't represent the language of the permit.
This stuff, there's a lot of interesting information in it, but you've described the changes you want, and we will determine that. Tim, could you review the the tape and just put down what the changes are, and we will have them at our next meeting to consider.
This is just a point of curiosity. Would you live with the permit as it exists?
Yes, we were willing to live with it. But as I understood it to be, we had to submit a new narrative, and that's what this,
And
I
that's what you've-
submitted was a
and that's what you've
narrative.
done.
And if we submitted the exact same permit that was issued, then we would have had to tear down the fence that was already erected. So that was changed. And at the time, we had heard that the the sound barrier wasn't a required element.
Does it make sense for us to show, even though we're still at the permit, sort of what we've done to try to appease some of the concerns that the neighbor may have, or is that not a factor here?
Look, when we discuss the changes, I think that your discussion of your efforts to appease the people would be in order at that point.
I'm confused again. Why would you have to take the fence down?
Because it's already up, and so the permit that you issued said the setback
permit was
had
allowed.
to be, the setback had to be 15 feet.
Oh, just relative to the 9 feet and the 15 feet?
Correct.
That's the only point.
And
How many feet does that go? I don't mean to be, I just want to get to the point and keep
Like
moving.
couple hundred feet.
No,
It's
no,
not-
New setback.
the no-
It's just
whatever
like-
that
It's
section
just
is.
that little piece.
30
that-
feet,
that
25, 30
section
feet,
there
40
is
feet.
40 feet.
I mean, that's 1 by 40.
It's this jog corner to here.
All right. Basically, it stops at his property line
The
versus.
property line
Yeah.
comes back and goes to here.
And again, I just don't understand why you would have to, take down that section of fence, is that all you meant?
Yeah, because it's already in
Up
concrete.
9 feet away.
Yeah.
Okay, I understand that, but you wouldn't have to take down the whole fence, just that little section.
No, it's the
Okay.
section.
Okay, now, does the board have any other, we've got plenty of time to, once we get the changes in writing so we can consider them. And once we've heard from Mr. Dunn, I think Mr. Dunn might be a good person to hear from next, unless anyone else wants to be heard from. Anyone else on the board? Okay, Mr. Dunn, you're up.
Hello, my name is Matthew Dunn. I represent Philip Joining and John Rowe. I also represent Jamie Cashman, who was the individual who purchased the Lepori property that was just discussed. Just as a preliminary matter on behalf of Mr. Cashman, he's instructed me to inform you that he'd like the same protections that this board afforded Ms. Lepori when it considered Thayer's previous application back in 2015, that process. So he desires the same sound attenuation along that lot line and all the same protections as she was provided. So I'd just like to clarify that and move on. Thank you very much for having me speak. I appreciate it. I submitted a memorandum via email to Tim. I also brought paper copies here for each member of the board, and I think I have some extra copies for Maggie and Josh as well. That just outlines, I don't want to go over, I understand that the board spent a very long time last year, as did Thayer, Josh, and Maggie, in presenting their application, but there are some open issues that my clients feel weren't addressed. The big one that that I have, that I'd like to address first, is really just from a procedural standpoint, and it relates to the special permit that was issued by this board and filed with the town clerk back on December 18th of 2015. As the board's aware, my clients did appeal that to the land court. That special permit has not been annulled. It is still actually live. The judge who is handling it is Judge Shire. What she did was issue a stay of that litigation pending the Attorney General's decision on the approval or disapproval of the further amendment to the landscaping section of the Town of Milton zoning bylaws, which, as we know, was approved and is why we're here today. But what I'm getting at is Thayer Nursery, as we sit here today, already has a special permit in place for landscaping that was issued to this board that has never been annulled, is still live, and is the subject of this land court case.
It probably should be withdrawn by Thayer. That would take care of it, wouldn't it?
Would it be, well, it's my client's case.
No, if the special permit was withdrawn by Thayer and the planning board sanctioned the withdrawal, that would do it, wouldn't it?
Procedurally, I don't know how it would work.
Okay, but I think something like that is what should be done, because obviously we don't want to have two special permits.
Right, and so that's what I'm getting at. I don't want to jam the brakes on this process, but I also don't want it to go forward if there's a procedural difficulty here with that happening. And I think that presently exists in the fact that
Right.
there is a special permit that's issued to Thayer that has never been annulled, that is the subject of this land court case. But as we all know, there's a...
This could be considered an amendment to that. I mean, there are any number of ways we'll do it. We'll run it by John Flynn and figure out the best way to handle this.
Okay,
And
well-
to get rid of the other one.
Okay, but I wanted to just point that out to the board, because I think that it is there's been a lot of moving parts here with regards to Thayer Nursery's use of the property over the last 5 years, and challenges to that use. And I just wanted to point out the fact that there is a special permit that's out there. That is issued under this specific section of the bylaw. So it's Thayer's going for a special permit, applying for a special permit that it already has.
Under the amended section. I mean, it isn't the exact same section. It's
Right.
a slightly amended section. But in any event, we'll take care of the old permit. We'll take care of it in the sense that we'll get rid of it. Or someone will get rid of it.
All right, well, that's a live issue here, so I wanted to point that out. The second indication here, point that I made in my memo is in point 2 here. In regards to the applicant coming before the board presently with unclean hands. Mr. Prondak, the building commissioner, was out to Thayer on the day that they actually submitted the application to this board seeking pretty significant zoning relief if you think about the neighborhood that they're situated in. They're asking to introduce or reintroduce certain commercial uses, pretty high-intensity commercial uses in a residential neighborhood. And that requires the issuance of a special permit. I mean, this is essentially a waiver of the otherwise requirement that only single-family homes are situated in this location. The planning board had issued, or the zoning board of appeal had issued a special permit back to Thayer back in 1967, and in 1987 it was amended, and further clarified in 2001 that talked about use of bobcats and laid out provisions as to how Thayer was to operate on site. And that was and is the law of the land. And when Mr. Prondak came out, as this board is considering special permits and conditions as to how Thayer is going to utilize their property and comply with what this board desires, it should keep in mind that Mr. Prondak found that they weren't complying with the special permit that was previously issued to them, as amended back in 2001. So, as the planning board is considering awarding this pretty significant zoning relief to Thayer, what my clients would ask is that before any decision is made, that Thayer come before the planning board with clean hands. And what that means would be spelled out in Mr. Prondak's cease and desist letter that was issued to Thayer on May 25th of 2016, just a couple of weeks ago, talking about compliance with hours of operation, which is another type of relief that Thayer is looking for. So, they're asking for it to change hours of operation, to be allowed to use bobcats and other machinery in this residential neighborhood. That's going to be restricted to certain times, and what I'm saying to you is there's already something in place that Thayer is not complying with. So, how can this board move forward with an applicant that already is in non-compliance with the bylaws? I just wanted to point that out. Again, the cease and desist letter is attached as Exhibit A to the memorandum that I've provided to the board. The third issue that my clients had asked me to point out, and that wasn't addressed in by the planning board in its December 2015 decision, is actually a matter that I brought up last March that deals with the eligibility of the applicant. As I understand it, there's 4 applicants in the present application before the planning board. Those are the Oldfield Family LLC, Thayer Nursery Corporation, Maggie Oldfield, and Josh Oldfield. one of the provisions in actually the very first provision is even the amended bylaw, further amended bylaw amendment is this eligibility prerequisite. And the language that I'm referring to is in bold in my memo in section 3 that talks about the applicant or the applicant's predecessors and interests on that date being July 2012, held a special permit or use variance issued by the Board of Appeals pursuant to, and now it's section 3A7D, which is the special permit that Maggie and Josh's father held, the type of special permit held in 1967, as amended in 1987 to, I think, provide for Maggie and Josh, or use variance issued by the Board of Appeals with regard to all or part of such lots. That is a prerequisite to being able to even get to be before this board. It's a eligibility prerequisite. And as I explained to the board before, the 1967, 1987, 2000 decisions, or the 1967 special permit was issued to Josh and Maggie's father and mother personally, and it's very specific, and I've already submitted the memo on that with the attachment of the 1967 permit. The 1987 permit expanded that eligibility to their children, of which Josh and Maggie are two. And again, that was personally, and it wasn't to be assigned. Fair Nursery Corporation has never held a special permit, nor has the Oldfield Family LLC under Section 3A7D at any time, and particularly as of July 2012. So, and I explain that further on page 3 of my memo. I'll let that speak for itself, but this is an issue that's never been addressed, and I think is impossible for Fair and the Oldfield Family LLC to get around. They didn't hold a special permit as of the date that was there, and therefore they're ineligible applicants as a matter of law. Now, with regards to Josh and Maggie, they did hold special permits via their status as the children of the permit holders of their parents in 1967, 1987. But they weren't operating a business. They weren't operating a landscaping business on the Thayer Nursery site in July of 2012. Thayer Nursery Corporation was operating the business at the Thayer Nursery site in 2012. So I'm pointing these out because they were never addressed, and you know, I'm giving an invitation to the applicant and to the board to address these, because I think that there are live issues. There are issues that are before the land court that have never been addressed by either the town or the applicant. And it's something that, you know, we just can't continue to turn a blind eye to. The fourth issue that I've pointed out is there's been some rumblings about, and it seems like every time we come before any board of this town that the Dover Amendment comes up. The Dover Amendment, as the board members are aware, is a exemption for agricultural uses from local zoning. The very fact that there's an application before this board seems to be an indication or a concession by Thayer that they're not eligible for the Dover Amendment. That representation by me is actually affirmed by the ZBA. We had numerous hearings back in 2013 and into 2014 on this very issue, and they indicated that the commercial uses of Thayer's property for landscaping, construction, and wood distribution took it outside of that exemption. That was affirmed by the Norfolk Superior Court back in October of 2013. So I think that's a non-starter. We can, you know, you can have a discussion about it, but this is something that's been addressed backwards and forwards, both by the town and by the court, that found that the Dover Amendment does not apply. 5 deals with how the commercial uses proposed in the application are in harmony with the residential zoning district. This is a requirement under the Zoning Act for the issuance of any special permit and warrants a discussion by the board. My clients have asked the applicant to provide them with an explanation as to how the wood distribution business that they propose to operate at 270 Hillside, 0 and 24 Forest Street is in harmony with the residential character of the neighborhood. They've also asked the applicant to provide them with an explanation as to why the property at 217 Hillside Street would not be a better base for the proposed reintroduction of the landscaping business and possibly the wood distribution business as well. And alternatively, they've asked why the landscaping business cannot be situated on that portion of the Thayer Nursery site located on the corner of Forest and Hillside Streets. I don't think that those questions were addressed previously. The sixth issue has to do with sound generated by the proposed commercial uses that are going to be reintroduced to the Thayer Nursery site. I know the applicant has submitted a report by Ascentech, I think it was back in July of 2015 with their previous application. That report, number one, doesn't address the number of vehicles that are going to be operated on the Thayer Nursery site. I think it only talked about the location of one Bobcat that was idling in one particular location, and didn't address the sound that would be experienced along the abutters lot line, or lot lines. That's Mr. Cashman's, Mr. Joe Ennings, the Tevens, and the Coles. There's a standard that's out there under the CMRs, and I cited in my memo, that talks about a maximum decibel level. I think that there needs to be some sort of study or representation done that the equipment that there's identified in its application, and I know that they had a list of 2012 vehicles. I think it's in the materials that are on the website. If those vehicles are operating on the Thayer site, what's the sound that's going to be experienced along the property lot lines? I think one of the goals of the bylaw that in the bylaw amendment that survived the further amendment that occurred back in February was that there's supposed to be this desire to have the commercial uses be in harmony with the residents, and that can't occur unless there's compliance with the decibel levels and requirements of the CMRs. That's further spelled out in the Kavanaugh-Tachi report that my clients previously submitted during this board's deliberation of the previous special permit. And finally, the information about the verifiable evidence as to the extent of Thayer Nursery's baseline activities. Those are established under the bylaw that Thayer's applying under. The activities on site are to be no greater than they were in July of 2012. There is a prohibition of introducing new activities. New activities would be those activities that were introduced after July of 2012. So they're to be at the same activities at the same level as they were in July of 2012. In summary, my clients think that the information that Thayer's provided is rather light as to the scope of the activities and the information pertaining to the particular activities that were there. I think that there was a single invoice from March of 2012 indicating that that somebody at Thayer billed somebody in the town of Milton for plowing services that were paid in cash, and would ask for some additional information as to each line of business that Thayer is looking to conduct on the site in order to gauge whether those activities were occurring in July of 2012, and if so, what the scope of those activities or what the intensity of those activities were, so a baseline can be set and gauged going forward by the board. Again, the specifics as to what I'm speaking to are addressed on page 5 of my memo. So I won't go into it any further. I'll let the memo speak for itself. But those are the issues. I hope they're not too many. I do recognize the board put in a substantial amount of time over the 2015 to address a lot of concerns, but these are the ones that are outstanding in the eyes of my client.
So-
Okay, now, this is fine. We're going to read the memo and be better able to address your issues. If you have any issues with the special permit, the current special permit, which is still around, you should identify them. And you have these issues, which I think would apply. Although in the current special permit, we make it clear that the LLC is the owner and not an applicant. So it really sort of comes down to whether or not there could be a proper applicant or not, and we'll consider that. But if you do have, if you do come up with issues, communicate them with Tim, and we will consider them. Now, thank you.
Thank you very much. Thank you.
We have a couple of pieces of correspondence. And what's the board's pleasure? I mean, usually we don't read correspondence because we expect the people who wrote it to appear and make their statement and be available for any questions. How does the board feel about that? I mean, certainly these people could, we'll read the letters, but if they want to communicate their views, it does seem to me better to communicate them in person and be available for any questions that people might ask.
I would agree.
Okay, so we do have a letter from Stephen Davis and a letter from Robert L. Jepson Jr., both of which should ask that we not approve this special permit for a variety of reasons. And we will read the letters, and if either of them, yes?
I don't have a copy of the letters. Could you just read the address of those two individuals for me, please?
Read the addresses.
Yeah, that's all I need.
Robert Jepson is 165 Hillside Street, and Stephen Davis is 285 Hillside Street.
Thank you.
Let's see if we have some other people who want to be heard on this application. And is there someone else out there who would like to be heard on this application at this time? We're not going to close the hearing tonight. As I say, we're going to have Tim determine what the issues are. We're going to read Mr. Dunn's memorandum, and we're going to hear further testimony at our next meeting. What else should we do tonight, other than hear? Yes.
Can I ask a question?
Certainly.
The applicants relative to the
Absolutely.
Mr. Prondak's letter. The letter says that Maggie Oldfield stated that Bobcats do in fact operate prior to 8 a.m. on weekdays, that their nursery is not subject to the conditions of the special permit. Can you explain that?
So back in 2001, which was 15 years ago, we were in front of the zoning board, and the zoning board put conditions on us, and we appealed the conditions. One of them was the start time. As you know, the town of Milton basically starts at 7 a.m. The accepted use is 7 a.m. start time for the DPW and for all other professional businesses in town. So when the ZBA put the time restriction on us, we appealed it in land court. So our attorney told us at the time that we can operate as to what our previous special permit had stated, and our previous special permit never had a start time on it. We always just abided by the accepted start time in the town of Milton. So for the past 15 years, no one from the town of Milton has ever come out and told us that we were in violation of the start time. We always understood that we could operate until we were told by a judge that we could not.
the zoning says that the conditions will be applicable, the conditions that we establish in the permit, and I suppose that perhaps the fact that the permit is not final has some relevance, but that the conditions we establish in the permit to related activities will control. So it does seem to me that if we, in the permit we issued for landscaping activities, we do control the use of noisy equipment, and it would control the use of noisy equipment by their nursery. That's my view. And that if their nursery, for whatever reason, because they say that they're entitled to do it because they're an agricultural use, if they do it, it still would be a violation of this, our own permit, because our permit says that the related activities have to be subject to the same rules. So whatever your attorney may have said about that, if we issue a special permit with similar language saying that rein in your other activities if you want to do a landscaping business. If you don't want to do a landscaping business, then of course, you'd have no conditions. You wouldn't have to do anything. You wouldn't have to provide lists of employees or anything. You could just not operate a landscaping business. That's the choice. And you say that no one else has ever been subjected to such treatment. No one else, I mean, Coulter had a certain amount of stuff that he had to do. So it's not unfair. It really, this is the price of admission to operate a landscaping business. And it just is the way it is.
I'm confused beyond that. What I think Mr. Prodak's letter says, if I'm reading it correctly, is that the zoning board of appeals granted a permit in '67, amended in '87 and 2002, and the zoning board of appeals permit said they wouldn't operate before 8 a.m.
And the other question I had asked was, as far as I understand, whenever any modifications are made to your special permit, it gets attached to your deed. So I called up the town to find the record of the deed, and there's no recording of these conditions on our deed. So that is why we did not think, and our attorney said we were really not subject to these conditions.
Try that one again.
She's talking about the zoning board of appeals made a decision. The zoning board of appeals decision was not recorded with the registry. It wasn't recorded with the registry because it was appealed.
And there was never a resolution from that appeal. It's still out there.
So we're only addressing
The
one
thing
letter.
is still being appealed?
Yeah.
Correct.
15 years ago, it's still in court.
Oh, and so, well, in any event, if we put it in our permit, it will be in our permit.
Correct, and we understand that, but their point was just to show that we're bad neighbors, and we're just explaining ourselves. We're not bad neighbors when the town for 15 years have never told us that we had to operate differently. They've had 15 years to tell us that, but they never have come to tell us.
What we've learned with the 8 o'clock start time is that it's challenging for the building commissioner to finger point a problem in a neighborhood when other activities start at 7 and we're forced to start at 8 and trying to determine if it's us who's in violation or is it our neighbors right next door at 7:15 starting excavators doing work up and down the street. And the finger is getting pointed at us. And when I hear a piece of equipment that go off at 7:15, I call the town and say, it's not me, and I shouldn't have to do that. I'm I'm nervous every time someone legally starts a piece of equipment up at 7 because I'm getting blamed for it. And that's what's happening.
And our other abutter is in the process of putting in a pool, and they've had a contractor there up until 9 PM. And again, I'm not complaining about it at all. They have had a water hose running down their driveway, leaking out, going all the way down hillside. And again, we were afraid we were gonna get a call.
This would be the construction, the bylaw on construction that unfortunately got derailed
And the way that
at
we
the
have
last town meeting.
The way that we have always operated has, and even though I fully understand the town of Milton does not have an official bylaw for noise, but the way I understood it is that they follow the DEP regulations. And so the DEP regulations is a 7 AM start time, and that has become the accepted start time in the town of Milton. And I believe the accepted end time under DEP is 9.
Now,
And believe me when I try to express to you that I'm just trying to understand this as much as anything. You now operate under the special permit granted by the Zoning Board of Appeals, correct?
In our opinion, we do not operate under the 2001. We operate under the 1987.
67 and 87?
67, 87, and it says 2002. I don't know if that's correct or it's 2001 or whatever, but.
Right, so
Why-
we
can-
have not been operating under the 2001 because it has been appealed and it's in the
Still in
court.
court.
And because the judge has not made a decision, or we have not, it has not been adjudicated, we are still operating under the 87, which technically has no start time and no stop
The
time.
the 1987 didn't address that.
No. So we have been following.
I don't, you'd have to
Accept.
give me some legal advice on how it's handled if something
I
is
think that it's
established by the zoning.
it's an interesting point, and a special permit that's appealed,
You would think that the permit would hold until the appeal said otherwise, but.
if they're not operating under it, I guess it was a neighbor's petition, so that they don't operate under it, because it was basically saying, don't do this. Interesting. I'll see if I can.
So it's just an interesting point in time. The timing's just interesting. The town has had 15 years, and it's just an interesting time now that all of a sudden the town is issued us a cease and desist. And since we've received that cease and desist, we have followed the 8 o'clock time.
So my question has to do with the special permit that was granted by this body in December. The judge declaring a stay on it. They
Yeah.
are not allowed to operate under this special permit, or they
No.
are? or
Landscaping,
they're not,
but then,
right?
but you can operate,
So they're not.
Nursery.
They're not obligated, though, to follow the nursery provisions of the special permit because it's been stayed. I mean,
Because
right?
they don't have a landscaping business.
Exactly. So I'm just saying, there was some reference to that, but really at this point, they're not required to abide by that.
But by
Until the
not-
special permit is
you'll
in
not,
effect.
I'm
not
sure-
required to abide by.
I'm sure Mr. Dunn has a different
No, I want to follow what
view.
you're saying, Cheryl. They're not required to abide by
The
which special permit? The
language.
zoning board of appeals?
This board's, which
This
is
one,
really
yeah.
the one I think we should be concerned about. This board's, because there was a stay, right? So as far as whether they're following something that the ZBA did and there's a legal challenge, that's really not part of our jurisdiction, right?
No.
And that letter, if it's addressing that, is really not part of our jurisdiction either. And if there's a dispute about that, it really is not for us to consider, I feel, because we're talking about the special permit that we issue. We don't get involved in the ZBA.
No, I agree with the yes and no. Yes, it's not jurisdiction, but no, I don't agree in the sense that you have to have some kind of concept of what the neighbors are doing.
Well, if it's, yeah, I mean, but
You have
if
to
we
have some
hear
sense
that there's a
of how it's
dispute,
happening,
yeah.
how it's being transpiring.
But I think what we're hearing is that there's there's a disputed understanding about it, which I don't think we can decide.
No.
And what we need to understand at the moment is, if it were under the special permit we're discussing, and it's not, we don't enforce the special permits that we issue, that would be the building inspector also. But if there's a discrepancy or misunderstanding, then who would that go to? If Thayer believes that Mr. Prondak is misinterpreted something, then who is then the one who decides whether that's true or not?
Well, I was just
Board of
having,
The
Appeals.
Board of Appeals,
But
right?
I-
So it doesn't really, I guess I'm questioning whether we need to spend a lot of time on that.
no, but I was, the conclusion that I just heard brought me to some contentment, and that is, they said they're no longer operating before 8
Okay.
relative to this request.
Okay.
Whether it's right or wrong, the request, they've abided by it, which I think is something to be said.
Okay, yeah.
If I could just say one thing, it just, for me, it's just a learning experience in saying that the 8 o'clock times probably won't work. And 7 o'clock is the start time it should be. If everyone else in the neighborhood is starting up at 7 and we're starting at 8, the same problems are gonna arise down the road.
But you haven't asked for us to reconsider the time.
No, we're
Correct.
we're
I
It's
still
just
said
at
that.
7.
re-emphasizing the
Okay.
point. That's it.
Because I really, after spending all of 2015, so many hours at this board, discussing all of the details, I really would prefer not to reopen any
Correct.
detail except what's been specifically requested.
Understood.
Because we spent a lot of time considering every detailed piece of information we had.
Perfect.
All right, so, now, is there anyone out there who'd like to be heard this evening on this application? And seeing none, it seems to me that we've gone as far as we should go tonight on this, and so we will continue the hearing until when, Tim?
7:30?
Until when?
On the 14th?
On the 14th?
Is that
7:30?
What are we doing on the 23rd?
23rd? We've got possibly Highland Street. I don't know if we'll get that one.
I think that we should do it on the 23rd.
23rd?
Yeah,
Yes. Second.
Second. Now.
sounds good.
It's only one of them.
Okay, well, give us a time.
7:15?
7:15.
We need to run this.
Oh,
No?
Hold on.
I'm not gonna be here the 14th.
Do you want to watch it on the tape?
No, I'm gonna be on
We're going to
vacation.
the 22nd.
I can watch it on
We're
tape
going to
after.
the 22nd.
23rd.
If something happened, 23rd, right?
Of June?
Okay.
Yes.
Something that would happen.
I thought we were talking
If
about
something
July
would
23rd.
happen?
No, would you be voting on that? You'd be voting on the 23rd.
Look,
Well,
we're going to
would you be?
continue
That was
till
the
the
question.
23rd and see what happens.
I'll be here the 23rd.
Okay.
I thought it was gonna be the 14th.
Is a problem on the next one.
There's a problem on the 9th?
On the 14th, there's a problem with the dates.
With who? With
I'm not
you?
gonna be here the 14th.
You're going to be here on the 23rd?
Yes, I am.
All right, so let's do it on the 23rd.
Yes.
7:30, was it?
7:15.
7:15.
You know how you said the board used to take July off? Well, I'm gonna take a week in July.
Well, that's better than nothing.
Exactly.
All right, see you all
Yeah.
in a couple of weeks. Now, we're going to hear from Mr. Sullivan, who has done it again and come up with a new zoning proposal.
Good evening, Mr. Whiteside. My name is Paul Sullivan, Smith Road, Milton. I had submitted for an informal discussion, a draft of a potential plan unit development or plan unit condominium development zoning article. And I have some basic assessors plans for the most part that kind of gives an idea of what properties would be affected by the zoning article. They either front on or are very close to the town access road, which is the former road to the landfill that used to operate at the end of it before it was capped for the golf course. There's a few interesting developments that have happened up here. First was the golf course development, which capped the dump and the landfill and created, I believe that it was 9 holes created on the Milton side of it. And then back in 2013, this board considered an assisted living zoning article that was eventually passed by town meeting. The one property that would qualify for that is the horse farm that is owned by Mr. Zazula. And that zoning would permit up to 100 units of residential housing. It is my understanding there is someone, an assisted living facility operator who was interested in the property currently and may be making a proposal to Mr. Zazula. So the other properties that would be involved, the qualifying square footage is 35,000 square feet. So 736 Randolph Avenue, 728 would qualify, Mr. Zazula's property, and potentially Lot 9, which was somewhat part of a subdivision that was approved at 41 and 33 Pleasant Street. The map I have, unfortunately, doesn't show the top side of the access road. I have it in combination with plans. So this was the subdivision that was approved by this planning board. And it shows the location of Lot 9, the town property which abuts this area where the proposed animal shelter is going to go, which is in this area, from what I understand. The 8-lot subdivision off of Pleasant Street, the developer agreed to bring water up to the edge of the town property so that the town eventually could loop the water main through the access road and service the animal shelter, I believe, is part of it. There is also potential to bring sewer up that easement as well. This is Lot 9, which is standalone property. There's an issue of frontage for the property. There is an unapproved 33-foot right-of-way there, and there's some dispute as whether that property has any rights of use and access and the right to improve it. So on the very upper part, I guess and some preliminary work done on the site, the town property where the animal shelter is going to go. This is so this would be Lot 9 right here, this parcel more or less. The town owns this parcel. I believe the animal shelter is going to be situated on that, either over here or possibly on the other side. There's also a small triangle of land the town owns right here, which is in front of Lot 9. So Lot 9 would not have frontage on the access road unless the town was willing to create an easement out to the access road. There is some language in the zoning that would possibly permit that property to be part of this article. So this is a little different than typical condominium zoning articles. It actually, most of them either are permitted multi-story garden-style buildings or townhouse. This has a little bit of a combination of both. it's, as, you know, it's a draft agreement, so I was unsure as what the town's position was, and some of the neighbors. There aren't a lot of abutters to these properties. The- To the first two properties at 736 and 728, the only abutters are the town across the way, Mr. Zazula's property, and the Driscoll's property. I have met with the Driscolls and informed them of this potential development and the idea of submitting the zoning article. At this point, they're open to it. They want to see what it's actually going to look like before they commit themselves one way or the other. They intend to stay there at that location. So I don't know if you've had a chance to really look through the article at all, if you had any specific questions regarding it.
Why do you think this is a good site for what you want to do?
There's a few reasons. First is it's a signalized intersection between Town Access Road and Randolph Avenue. With the animal shelter going up further up the Town Access Road, there's going to have to be some improvements. I don't know what level of improvements, but some improvements for the public to get up there. If this, if Mr. Zazula's site is developed as an assisted living facility, part of their zoning would require them to improve the town access road. So it creates an opportunity to develop the site. There's, it's somewhat of a TOD, a transit-oriented development. It does have public transportation access. Right near the intersection, there's a bus stop there that goes to Ashmont, goes to Central, and I'm not sure if there's one that goes into Milton Village or not, but. So, since the zoning is already in place for the assisted living, which allowed a significant residential development, and since there aren't that many abutters to the area, and this roadway is going to be improved likely one way or the other, that it seemed it might be a good location for a denser development of this site.
Which parcels is it that you develop?
It'll be, Mr. Zoller's not part of it, although he's here tonight. He's in discussions, I believe, with assisted living facility developer, and I'm not sure where that's going to go. This property here is, the Lot 9 belongs to Rob Celebrity, who's the developer of the subdivision at 33 and 41 Pleasant Street. He's here tonight. And the main property would be this, the White's property here, which is 70,000 square feet. And then the other property is 35,000 square feet.
So those two parcels, the 35,000, it looks like the other one says 52,300, although I can't read it that well.
Yeah, it's not the best copy. It's actually 69,800 and something, I believe, or 69,611 is the total. There's two different parcels there. So,
Maybe I do see something like 68 or 69.
yeah, the White's, it's 728 is 69,000, I believe.
So it's those two lots. Yeah.
Right. So, you know, there's a lot of walking trails up there. The golf course is there. There's a good potential that an assisted living facility is going to there, or memory care. And it seems like it's a good asset for the town that could be developed and provide significant revenue from what it does today. And it's, you know, it's a safe situation as far as getting in and out of there with the street light there. And then there's public transportation at the end of the street as well.
If all the available land were combined, how many units could you build? Including the assisted living site, how many units could you build under this zoning?
It hasn't been calculated. We really haven't hired an engineer yet.
It would be hundreds, would it not?
I don't know if it'll be hundreds. I'd say between 100 and 150 maybe.
Paul, this zoning doesn't appear to be site-specific to me.
Not to an individual lot, but more to the area.
It seems to me there's a lot of language that goes back and forth between townhouse and garden style and single floor living and not, and then it allows 45 feet. So it allows pretty much a whole wide range of things here.
Right, it's a draft, and I wanted to cover both and see which way the neighbors, the abutters, the planning board, the selectmen, and, you know, how the town feels about it.
Alex, what's the status of the condo working committee?
It's basically defunct.
Okay,
I was gonna say hiatus, but.
that's too bad. This would have been a great thing to refer over there.
Well,
Why can't we recall it?
well, we'll put that on the agenda for the next time.
Yeah, we'd be more than happy to go appear before them. But, you know, given the existing zoning that the overlay that is in the neighborhood, and given the opportunity to improve the roadway and the existing street light there, and the public transportation access, it seems like it's a logical place to maybe allow a denser development than what's currently allowed under the existing zoning.
But of course, some planning would be required to determine just what would be right,
Sure.
because just not anything.
But the overlay zoning you're talking about is the assisted living. Is that what you're referring
Existing
to
one,
when you say
yeah,
there's overlay zoning?
Yes, there's overlay zoning on, the one property meets that zoning, and that's Mr. Zazula's property, the horse farm, yeah. The other properties don't meet that zoning.
Are you suggesting that the two lots combined could meet that zoning also?
Not likely, no. I think the only property up there that could is Mr. Zazula's.
And are you suggesting that lot 9 of the other subdivision might be subject to this zoning as well?
Yeah, it's a complicated situation, but it's, you know, it's potentially could be built on.
And when you say complicated, you're talking about frontage and access?
Yes. But it, you know, if some type of zoning such as this was considered by the town, it seems like it'd be kind of a waste to let that parcel sit there and not incorporate it into the zoning.
And you say you've had preliminary conversations with the abutters on Randolph Avenue?
Well, the only one yes, the Driscolls, which are the only ones that abut the properties that I'm involved with, yep. And I've spoken to Mr. Zazula and gave him a copy of this, and I've met with Rob Celebrity. He has a copy of it, too.
Well,
I think, we spent a lot of time last year drafting zoning, Paul, and we heard often that it was done too quickly and without enough input, and there was a real fear of unintended consequences. So I use that, I say that as a caution only because I think, you know, I think the condo working committee would be an important voice on this. And also, I think it would be important to identify other potential sites that could be impacted by this up and down
Sure.
Route 28 and potentially other state highways. I guess that's probably the only one, but you know, make sure even residential properties, there are probably a few along there that might be able to be sold individually and then converted to condos. So those are the kind of questions that, you know, to even move this thing at town meeting are going to have to be answered early and discussed.
Right, I agree, and that's the reason this wasn't submitted as a citizen petition. I know it needs a lot of work, and it's our intention to you know, attend a lot of public hearings and talk to the neighbors and the planning board and the selectmen and try to work an article that works for everybody that's involved.
And we think that our planning staff should take a crack at this, because this would be a excellent thing for them to take a crack at. So, why don't you, planning staff, do that? And Paul, we will give this some further thought.
Great. Well, thank you for your time tonight.
Thanks for coming and sharing. Let's take a look at the agenda and see if we haven't heard from the planning director recently. What have you been doing, Phil?
I have been going to the Conservation Commission for the animal shelter, mapping the wetlands for the potential site. The plan that Paul had up there is the one that I developed for the animal shelter. Doing the same thing over at the rink for the repairs to the parking lot outside of the Zamboni door. The contract for Curry for next year to run the rink. Getting a lot of comments from neighbors on the Carberry estate. Coordinating the East Milton letter for the deck project. Working with the Mass Department of Transportation, Howard Stein Hudson, and VHB on getting a proposal to Federal Highway in the next several
A
weeks
proposal to what?
for the deck project
A
to,
proposal to get their
use
agreement
the-
that you can do it.
thank you, yes, spend the existing money.
What are we
It's
gonna,
actually not our money, it's actually federal money on a state project, so the state is the proponent, not us. We'll have input to it, but it's their project since it's their land.
I'm sorry, Bill, what are they gonna do with the deck?
The proposal is to take and put parking on the boulevard end and to take the, redo the park that is on that end now and go all the way down to the slip lane. There's like 25, it's proposed to have 25 spaces at the boulevard end of the deck project.
You're losing, which end's the boulevard end? The fire department?
Between the Shell station and the fire station, that road right there, that's boulevard. Writing it, coordinating with town council for a DCR curb cut letter for the Pulte Governor Stoughton project.
When are they going to come in?
Probably the end of July, beginning of August, but I think end of July is more.
They have been urged to come in a long time ago, and they haven't.
They actually made a comment that they wanted to go to the selectmen and start there, then come here. And it got pushed back, and now they're going to just file and come here. They're filing with MIPA, they're filing with DCR for the curb cut.
All right,
Then
well,
they'll come in here.
it would have, we were available to
think they should come
discuss informally what they wanted to do. If
I
they want to
agree.
file an application, that's up to them.
I agree with you, I think they should come in pre, but we'll see. Signs, still dealing with signs.
We're going to hear from Tim on how we're doing.
Yeah, you're hearing from Tim on the bylaw part, but the implementation
Oh,
of
the
the
implementation
existing,
of
on the
signs.
existing signs is what I get to deal with.
Sorry, Bill.
Yeah. Dealing with a extension of the, for the selectman's office on 88 Wharf Street's land use, one of the parcels there. And coordinating with town council on a Greenspan letter for parking down in the square.
Excellent. Tim, tell us about the sign bylaw and how soon we're going to be ready.
I have I haven't set it up yet, but I spoke with the building commissioner about meeting next week. I'm in the process of drafting up some ideas and principles. I actually also have a lot more questions than answers as I've been going through this.
You want us to answer some of them tonight?
No, but I mean, there's issues that sort of go beyond, the kind of standard size, number, orientation, the issue of awnings, the issue of second floor businesses, directory signs. I have directory signs twice for some reason. There's administrative things in terms of forms and checklists and guidelines that are going to need to be reconsidered. It's just a lot of, if there's going to be a new sign bylaw, there's also a lot of kind of things trailing behind it that need to be kind of on the same path and on the same timeline. But I'm in the middle of assembling those. I think I'll have a memo with some ideas to send out to Bill and Joe and you, hopefully early next week. I know that the next meeting on the 23rd is a further discussion of process and standards and whatnot. So I think we'll have some good preparation for that. It's one of the things I'm doing is trying to do some sort of test fits for how big should signs be, how small should they be, and kind of trying to use some of the existing business kind of facades in town as a way of determining, how to do that. It's a tricky balance, but I think it's important. So we'll have plenty of hopefully pictures and stuff next time.
All right, thanks. We're going to sign the 865 Brush Hill Road special permit amendment. We've got 4 people here.
No, I wasn't here to vote on that, do I?
We could make it into a site plan approval amendment.
Which I
Okay,
could
we
then.
can- Or we can wait for Brian if you like.
If I were here to vote, I would have voted.
I will stop by Monday morning.
And
as soon as I
sign
can
it.
and sign it.
Okay, the only change I have in your proposal, where you say including input from the Dana Avenue abutter, since the Dana Avenue abutter wanted gray, light gray, and we determined dark brown, it seems to me we could take that, we could take the words including input from the Dana Avenue abutter out of it.
Where does it say that?
It says it in decision.
He said he wanted gray, but he really didn't care.
He didn't care.
I understand that, but,
He did-
okay,
he
I
did
mean,
say-
if he didn't care, then
didn't care.
then we can
It's-
leave it in and
it's
just
still-
sign it.
Just to clarify that point, he didn't care. The other point that I would make is that the wood we chose ultimately fades to a gray color. So that was, I think I would leave it in.
I
We're in
don't
agreement.
think that it is going to age to a gray color. But it may, we're going to have to wait and see.
Yes.
Okay, leave it in. Now, give us a signature page and we'll sign it.
I only have one
All right,
now,
I
so
will,
you've got one.
I will
I have one.
sacrifice my copy.
Okay.
I'm going to go
I
on
don't
line
sign it.
2. April, you're going to go on line 3. Mike, you're going to go on line 4.
I think they all have pens.
How
They all
many
have
copies do you want?
3?
All right, it doesn't matter.
That's why we do it in blue. While you're signing and have an open ear,
Should I switch to blue? I have a blue in it. I thought that was blue.
Okay, how are we doing here?
can we talk about the wall?
Yes, I think we should talk about the wall.
You mean Donald Trump?
No, not that wall. Brush Hill Road wall, Beechwood Lane. Alex and I went out and met with the developer. We met with Tim Kernan, and after much discussion, the original plan had that wall bending up to the property and leave it alone. The whole idea was don't touch that wall. So the developer did not touch it. When he was here to get his definitive decision, the idea was to take and go from that wall down and make the turn up into Beechwood. He started to do that, and he came up with a really funky, it had a little jog in the wall that he grabbed a wall with a bend, with his own bend, so it had a point in it, that an inverted point that didn't need to be there. Alex and I looked at it and came up with the idea, well, forget that, let's make the wall come straight and then follow the same arc so that it looks like it's one piece. If we took the old pieces of the wall, there's red stone in there, they'll take the red stone and put it in the top course of the new wall as it wraps and goes up the street. It takes away that little invert in the wall, straightens the whole thing out, and it becomes a decent wall.
It looked like a good plan, but Tim said that this wrecks the whole notion of the development. And so the question is, the developer wants to put his finish coat on the street because he's got a lot of people who've just spent millions of dollars on some of the houses, and they don't have a very good entryway. And the wall really needs to be
Completed.
completed, but weeks ago I said, advertise the thing and we'll determine it. Weeks ago I said this, and nothing has happened because saying that it's simply a minor modification of the subdivision plan doesn't get us anywhere. And at the very least, it seems to me we should get that ad in and have the hearing. If we can't get him to say this is fine and insubstantial, let's just bite the bullet on this thing. Because
I think we decided that at the last meeting.
I did it. This has been my position for a long time.
I think we did agree that you would go out and look at it with Bill,
I
right?
did.
Yeah.
Yeah. So, I think that what the developer wants to do, I mean, there are, one of the issues is that there are gate posts, stone gate posts. And Tim says these stone gate posts are totally inappropriate. And, I look at them and I think they're sort of nice, but
We're responding to a single abutter. I think we need to have a public, let's have the advertised discussion so that we can.
advertise it, determine it.
I would suggest that they bring in some photographs
Yeah.
of the conditions. It would make it much easier for us.
Right.
Yeah.
And if people want to look at it,
And drive by.
it's just off Brush Hill Road.
But for the purposes of a public hearing, I think it's nice to have the photographs so people watching can see
Right,
it as well.
exactly.
Yeah.
But let's mark it up, have the hearing as soon as possible, and we will attempt to determine it the same night as we have the hearing, because the developer has been hanging for a long time.
If I have to put it in for 2 weeks, the first time I can go is July 14th.
Well, the position we have had is that this is really big. That's the position that we've gotten. This is, what the developer wants to do is just totally inappropriate, and we're going to have to do the 2 weeks, unless you do the ledger and can get it in quicker. Depending on what the developer wants to pay for.
Yeah, I mean, if he's willing to pay for the faster advertisement, I'd love to see it on the 23rd.
I'll ask him in the morning.
Great.
Okay,
Well, is it 2 consecutive weeks or is it 14 days?
I think that it's 14 days before the hearing.
That's
That,
today.
That's this morning, yeah.
Yeah, so then we're out. So then it's the 14th.
That would be the first one and then the second one. I think that's right, isn't it, Bill?
14th.
Okay, well, in any event, it's too bad, but try and get the folks up there to reach an agreement, because these new homeowners are not a happy lot.
And they can't put the final coat down on the road until
We
the wall is.
we understand that. That's why they're not a happy lot.
You know, it would be helpful if some of those homeowners showed up for their own driveway and gave us an opinion of what they felt about the road as well.
I think so. I think we've gotten to the end of our agenda. And
I have one old business item I just want to update.
what is that?
It's about Kinsale Lane. And it wasn't actually a planning board issue, as we determined, but you'll remember a couple meetings ago when the modification first came up, I raised the question, why were occupancy permits issued when the conditions of the plan were not met with the construction of the road? And I think we all agreed that that wasn't a planning board issue, and I said I would take it up with the town administrator, and I just wanted you to know that I did, and she investigated, and it was determined that this was an unusual circumstance, and she's going to look at policies and procedures to make sure that doesn't happen again, which was my overriding concern. So I thought you should know.
Well, I think that we definitely don't want it to happen again.
Exactly.
Yeah.
Having spoken to the building inspector about the same thing, it does come back that we've had a lot of private ways lately. When you have a road that is accepted, that's going to be town accepted, there's one set of standards. When you have a road that is a private way, we have been allowing a covenant, and the covenant has waivers attached to it. It's those waivers,
What sort of waivers?
the width of the road, the length of the road, the utilities, a private way, the different ones
Well, I
that we
mean,
allow.
we
It's-
specified that in the subdivision decision.
Right, but it's in but those go into the covenant.
Right. The covenant is we
covenant-
agreed to build the road according to these conditions.
And it's who follows the covenant is the issue.
But who is
Because-
bound by the covenant is the issue.
And when the lawyers for the two properties don't catch it and one sells, that becomes the issue. That sale
The
shouldn't have
covenant
taken.
by the owner not to sell until he's done the road.
But when he sells a piece of property, it shouldn't have gone, there's two lawyers for that property. One of the two lawyers should have picked it up, that, whoa, there's a covenant that goes with this. Where's the signature on the covenant, and has everything from that covenant been done? And that's what's happening here. We have a covenant that gets filed.
Right, but then
And
you
they
get
just
the
filed.
building permit, and the question is, do you issue the building permit if the road hasn't been built? And
We're not putting in, but we're not putting in that it has to be. Normally, if it was a road that is going to be accepted by the town, we would be asking for a bond. We haven't asked for a bond because we've allowed that covenant to take its place. It's in section 5 of our rules and regs
we-
that you could do either or. If we're gonna do a
But the
covenant,
covenant is basically supposed to be a covenant that you won't sell the lot.
Yes.
And there's a title defect.
and that's what I'm saying, that it is getting by two lawyers on the Kinsale Lane one. There's one other piece of property that it's, the same thing has happened to. It just
So maybe
becomes,
we should require, I mean, it's
I
up
think
to
we need
us.
to
We
put
can require a bond.
we need to have the bond in place to be able to go back and fix these problems.
Yeah, we need to start putting it as a requirement in the special permit.
Yes.
In subdivisions.
Yes, correct.
I
I
think
pay them
that,
all the time. It's a very standard practice.
but you know, they,
pay further.
it really is true that if there is a covenant that you cannot sell the lot
I agree.
with,
But-
but I'm just saying that
We pay for
if
it
it's
through
there, that should be enough.
But
Well,
Kinsale's,
it's enough to protect Tony Ambrose. He can probably go back to his title insurance company and sue if he wants to.
Maybe we can go to his title insurance company.
his lawyer's a
So,
relative.
I mean, my interest in this was that the plans that are specified by this board are what we see constructed. That's it. So we'll continue the conversation with Anne Marie
And
and we'll look at
The
policies
building
and
inspector's
procedures.
going to be happy.
And we should keep it in mind when we're issuing subdivision
I
permits.
think that we should, I think that a bond is always a good thing.
It induces the right thing to happen.
Exactly.
It does help induce good things. All right, anything else? We made it by 9:30, which was our
Can I just say
stated
something?
intention. Oh,
We should explicitly push the reorganization of the board forward to the next meeting.
we're going to not reorganize tonight. We're going to possibly reorganize at our next
23rd?
meeting, but who knows?
What do you say, Mike?
In flux.
What?
What do you say?
I move that we close the meeting.
Okay,
Second.
all in favor?
Aye.
Hi.
Bye, Brian.
Bye, Brian.
Bye, Brian.